The webinar is going to be basically about, you know, stopping them in court and the things you need to do before you get up to the court part. But what I'm gonna do is I'm gonna play a couple of recordings. These are actual court recordings, and this first one I'm gonna play is leading up to what we did in a meeting one time in one of the groups. I can't remember which one it was. Was the second? Well, I did it with everybody, I think. Is leading up to what we did in the meeting one time in one of the groups. I can't remember which one it was. Was the second? Well, I did it with everybody, I think. Let me turn my video on. So listen to this recording. It's going to actually show you what I used in the case to fight it for this gentleman. Just to give you context, the guy, I think I explained this in here, the context of this. So let this play, and then we'll come back to that, and we'll go from there. So this is one of the actual templates y'all going to get, along with two others, to help see how you draft your cases. Then I'm going to send you guys a PDF of Richard Cornforth's book. I was able to locate it on the internet. I paid for mine, but it was one floating around there. So I'll give that to you guys to use. Those cases are very good and powerful guidances for winning in these debt collector cases. All right. Any questions before I move to show this video? I know I didn't talk about it a whole lot. All right, let's go then. No questions? All right, let's do that. Let me know if y'all can hear the sound. Can y'all hear that?
Yes.
Yes.
Can't hear you now.
Can't hear you.
Hold on, y'all can't hear that? I paused my mic. Let me make sure when I share the screen, it's supposed to play the sound. All right. All right, let me make sure I can hear this. How's that?
I still don't hear anything.
Don't? Okay, what is going on? Why isn't this playing? Hang on, y'all. Of course, when it started, it's let me stop the share and just start it over here. Stop. Share. Were y'all able to hear my Reverend Ike stuff that I was playing earlier?
No.
Y'all wouldn't hear nothing? Oh, okay. Something's going on with Zoom, because usually you should be able to hear the clips. I'm going to play it now. Let me know if you hear it.
Yes.
All right. I just need to move. How's that? Just chat out of the way. Okay, alleged defendant's motion to vacate board judge. Will y'all able to hear that when I played it?
I can hear the case.
Okay, good.
Yeah, we can hear it.
All right. This one, the authority of Florida statute title. I think that's, what is that, 7? What's Roman numeral is that? 6? Or 7? 7, right. Yeah, okay. Yeah, when it's going forward, 5. Yeah, okay. Chapter 90.203, compulsory judicial notice upon request. So I threw a bunch of things in here. Brief and support a motion to vacate. Michael S. Thompson, but not, see how I did this? I did, because this is how they had a caption. I don't go in and try to make a point of being obvious. Well, I'm being obvious, but I'm not focused on that all cap. Because one thing, this is a civil matter, and they're trying to get money. They're not trying to lock you up. So we have to distinguish where we're going to pick battles. An aggrieved party moves this court under the authority of Florida Statute Title 7, Chapter 90.203 for vacation of void judgment attached for lack of subject matter jurisdiction. Markov Law LLC and William Weisbeck, practicing subterfuge and acting in a purely criminal mode, obtained judgment in this instant case. Michael S. Thompson did not receive notice and have opportunity on motion for either default or subject summary judgment, even if Markov Law Firm LLC and William Weisberg is the attorney, so I just want to let y'all know that. Had properly noticed Michael S. Thompson, the records does not reveal that Wells Fargo Bank N.A. proved standing to bring this action, and Markov Law LLC and William Weisberg failed to prove up the claim of damages. The court relies solely on attorney unsworn statements. See Wright versus Emory's attorney unsworn verified statements do not establish competent evidence. Hewitt Coleman Associates versus Lemus 460. I won't read all of that. The practice we wish to see terminated is that of attorneys making unsworn statements of fact at hearings which trial courts may consider as establishing facts. It is essential that attorneys conduct themselves as officers of the court, but their unsworn statements do not establish facts in the absence of stipulation. This is what I read on YouTube. Trial judges cannot rely upon these unsworn statements as the basis for making factual determinations, and this court cannot so consider them on review of the record. If the advocate wishes to establish a fact, he must provide sworn testimony through witnesses other than himself or a stipulation to which his opponent agrees. Usually, when they talk about stipulation, is that sometimes they'll send you a questionnaire to answer. Do you live here? What is your name? Do you know Wells Fargo? That's the stipulation. When you fill that out, you just stipulated that they can use that in lieu of having a witness testify against you, either by sworn statements or sworn verbal statements in open court. So when you get, they always send a questionnaire for you to fill out. You don't fill that out. And say no, rebut that, say no, I'm not give testimony against myself. I forgot the term, but anyway, you understand. You don't fill those out. Memorandum law in support of the point of law that party seeking to vacate void judgment is invoking the ministerial powers of the court. Courts lack judicial discretion when it comes to vacating void judgment. So they don't have, if they don't have that evidence there, they can't, they gotta give you your win. That's what I'm trying to get you to realize. They have to. That's why when the brother was talking to me yesterday, I said, you need to read what I gave you over and over. Read it because you will need to recall this when you're in court. So when rule providing for relief from void judgments is applicable, relief is not discretionary matter, but it's mandatory. Ornery, Shalala, 30F3D, 1307, Colorado, 1994. See also Thomas 906 SW2D at 262, holding that trial court has not only power but duty to vacate a void judgment. So they have duty to do it. For other authorities concurrent, see Watkins v. Johnson. A judgment that is absolutely null and void, a mere brutum fulmen, can be set aside or stricken from the record on motion at any time and may be collaterally assailed. It is determined that the judgment entered is void. The trial court has no discretion but is obligated to vacate the judgment. Every court, whether possessed of original or appellate jurisdiction, is vested with inherent power to vacate its own orders, judgment, or decrees. If void, and indeed every such court is in duty bound to do so when appropriate procedures invoked for that purpose. So you have to invoke them to shut it down. Now I use judicial notice, but you ain't gonna see a judicial notice that like that on anyone else. They're using that bare bones judicial notice. This here got teeth in it. This court is noticed as soon as practical and reasonable that Markov Law LLC and William Weisberg, the private business organizations to which they belong, and all who aid and abet Markov Law LLC and William Weisberg shall be sued under the authority of 18 USC 1964. I'm opening up a suit. He got opportunity to sue him. Uh, attorney buying evidence. Let me fix this. Attorney Every attorney buying evidence of debt misleading court. Every attorney who either directly or indirectly buys or is interested in buying any evidence of debt or thing in action with intent to bring suit thereon is guilty of a misdemeanor. Any attorney who is in any proceeding before any court of justice of the peace or police judge or other inferior court appears as attorney willfully mistakes any proposition or seeks to mislead the court in any matter of law is guilty of misdemeanor. And on any trial, therefore, the state shall only be held to prove to the court that the cause was pending, that the defendant appeared as an attorney in the action, and showing what the legal statement was, wherein it is not the law any person guilty of falsely preparing any book, paper, record, instrument in writing, or other matter or thing with intent to produce it or allow it to be law shall be guilty of felony. See Florida statutes title, I don't know what that Roman numeral is. Offenses concerning racketeering and illegal debts. Demand. Wherefore, Michael S. Thompson, but not Michael S. Thompson, aka Michael Thompson, respectfully demand vacate void judgment under authority of Florida statute title 7, chapter 90.203, compulsory judicial notice upon request. I didn't put DBA, I put AKA and but not. I didn't do all of that. Affidavit. This is the affidavit I read on the air on YouTube. Here's the affidavit that they have to rebut. I'm not going to read all that again, but I'll go down to this, which I didn't read. So he gave him an affidavit and he said, y'all got 15 days from the verifiable receipt of the motion to vacate a void judgment, and orders shall be prepared and submitted to the court for ratification unless prior to that time, Markov Law LLC and William Weisberg rebut all articles 1 through 5 of my affidavit by and through a competent fact witness making their statement under penalty of perjury, supporting all rebutted articles with evidence which should be admissible at trial, and sets the matter for hearing. So they got to go back with his affidavit, which they will not be able to do, and you'll see how they avoided it. So let's go to the recording. Let me find it. Find this recording. What's connected? That's my camera. Hang on, y'all. I'm gonna shut down my camera for a second while I. Come on, open up. Oh, they trying to play me now.
And this is on a motion to vacate a void judgment.
Yes. Okay. The judgment was it was set aside February of last year, February 20th last year. So he set it for a mediation, and I was I put in to vacate it because they arrived at the decision without any sworn testimony, sworn affidavits, any fact witnesses, competent fact witnesses testifying. So all it was the Natherpour and Associates. They were just they was like testifying, instead of having a fact witness or some type of sworn affidavit. So it was all like hearsay, like third party hearsay coming from Natherpour and Associates.
Was this resolved at mediation, Mr. Thompson?
I'm sorry, I didn't hear you.
Was this resolved at mediation?
No, it wasn't. No, it wasn't resolved. We didn't have a mediation because of COVID, due to COVID.
Gotcha.
But I was just I just wanted to vacate the whole order, being that it was like they didn't have the evidence. They didn't prove their case of the damages, being that they didn't provide a fact witness.
Okay. Mr. Johnson, would you like to respond?
Yes, Your Honor. We did file a verified motion to strike the defendant's motion to vacate the judgment as moot. There was a judgment that was signed by the judge, Judge Davis, it looks like on February the 20th of 2020. However, that judgment itself, it didn't show up on the docket, and it wasn't, I guess, recorded until recently on looks like July the 14th. But the judgment has been set aside, so that's why we believe that the motion to vacate judgment is moot.
I'm gonna stop right there. Now, the wording, he was saying competent witness, competent fact witness. He should have just simply said the original. Hold on, people are trying to get in, of course.
Can't hear you.
Oh, y'all can't hear me? Hold on.
I can.
You can hear me?
Troy can.
Yep, loud and clear.
That's better now.
I hear you.
Oh, that might have been your computer, brother, because nothing changed it over here. I'm talking right into a mic.
It's always my computer.
Yes, it is, because the other person said they can hear me.
I see it.
I
I
can
hear
hear you
you.
too.
Who else can hear me?
I can. This is Antonio.
Right. Okay.
I can hear you.
I got
Theodore
you.
can hear you.
I can hear you too.
I can hear you.
No,
Please never say.
we got a unanimous decision. The way he expressed himself in court could have been better. Like, Your Honor, what we have here is attorneys making testimony against me, basically slandering me. They don't know me. I have never met these guys before. They might be nice guys. I don't know. But right now, I'm offended that they're coming into court saying I did something without bringing a proper witness into court that I can question under oath to the facts here. So he could have said that. Then the attorney comes back with he wants to mute he didn't. Now, the reason why I read the motion, you notice he didn't say anything about the meat of that motion. He didn't say anything about the competent fact witness. Oh, yeah, we did this. We muted it because it was set aside. So he decided not to challenge anything. So let's keep going here. All right.
Okay, so there was no additional judgment that was entered after the motion, after that particular judgment was set aside.
Yes, that's correct, Your Honor. After after February the 20th of 2020.
What?
Okay.
I'm sorry.
And so basically the case was, I guess because of COVID, nothing happened on the case from that time until this year.
Okay, so then why did you file for garnishment if there's no judgment?
And Your Honor, that was an act. Well, it was a mistake.
Y'all notice he's starting to backpedal, right? He's trying to ice skate backwards right now. Listen.
For some reason, it was showing as still an active judgment in the court in the plaintiff's case file, and so we filed it. And when the defendant filed the objection, and we did further research, we immediately did a voluntary dismissal of that.
Okay.
Yeah. See, if he did not file that motion, they wouldn't took his money. His job would have gave up his bread off of that order that was set aside. And they knew that. They just wanted to take advantage of the fact that he may not know what he's doing. They wanted to take advantage of him. They didn't know that he's part of the hindsight team. So they figured they could pull a wool over the court and sneak attack him, and he wouldn't know what to do. But let's go. Let's keep listening.
So basically, just so you understand, Mr. Thompson, there is no judgment to set aside. The case is open. So they're not entitled to anything right now. They haven't won. You haven't won. The case is as if nothing has happened.
Yes.
So what
I'm sorry. Go ahead.
I would assume is set down a trial date.
Well, Your Honor, we, because there's still a motion for summary judgment that has been filed, we would ask for to coordinate a hearing date for that motion.
Okay. When are you available to hear that?
Your Honor, we'll make ourselves available whenever the court can give us a date, or if you want someone from our office to coordinate a hearing date.
Wendy?
See, 1 minute he was trying to get the money off the judgment through garnishment. Now he's saying, well, okay, there's no judgment. Now we need to reinstate our motion for summary of judgment. Now he's backpedaling. See, there's a scripture. How can you take the straw out of your brother's eye when you have a rafter in yours? Now, if you understand what that scripture is saying, that means that on one hand, I cannot fix anyone because I got a big old blockage in my vision. And my blockage is I'm still trying to get it right for myself. I can't see around my own issues. So any information I'm giving you is going to be incomplete. It's not going to be consistent with what you need. That's why I always say the best answer I can give you, go within. Study the words yourself. Read things yourself to kind of give you enhancement. I read stuff like Reverend Ike stuff to remind me of my power. Because sometimes I'll forget. I'll get lost. And stuff like this bring me back. I'll read these things over and over again. I'll listen to the same recordings over and over again. All right. Peace. I'm sorry I'm late, y'all. On the phone, talking to the missus. We had a conversation. We were talking. And so I had to put things off a little bit. But hey, I'm here. I'll let y'all listen to a case from, oh man, a COVID, during COVID case. Yeah, that was way back when, right? It seemed like just COVID was just yesterday, but it was like what, 2020, you know? But before I get into anything, I do have to take I got to take in something really quick that just popped up. It's gonna take me about 2 minutes. I'm gonna go back to that debt collector case and let y'all finish hearing what he was talking about.
Okay, is there anything else to come before the court on this matter?
No, ma'am.
Something happened. Okay, well, it doesn't matter. Motion of judgment when there's just a general denial. If you just say, no, you don't raise any valid affirmative defenses. Did you file an answer in this case? Right, here's your answer. Let's look at your answer.
Okay.
Okay, so you put here general denial.
Right.
Causes of action. Defendant denies generally and specifically contained in said complaint without information. And then you have your affirmative defenses here. Failure to state facts sufficient.
See, a general denial is not going to work. And this is why we're this far in the case.
Time barred. And this answering defendant alleged that plaintiff's own conduct stops parties and interest barred under federal law, court and satisfaction, damages, collection, estoppel. I mean, I don't see in your answer, Mr. Thompson, and it's up to you whether you want to, I don't see where it says that you never took out the credit card and this isn't money that you owe.
No, this is something, I was with a credit company. And this is something they filed. They just gave it to me and told me, "Hey, file this," because I was with a credit company.
Okay. Well, if you want to change your answer, I would advise you to do it before the summary judgment, because that's certainly what their motion is.
No, yeah, that's what my motion.
Now, she wasn't supposed to tell him that. She just gave him legal advice, but it was good advice.
Was today is the I'm challenging subject matter jurisdiction. That's what my That's what I'm here today for, to challenge this, the subject matter jurisdiction.
You're here today to challenge a subject matter jurisdiction.
Yeah, to vacate the summary judgment on the
Okay,
basis of
but
a
that's already, that has been vacated. There's no, I have motion to vacate void judgment.
void judgment. Yes.
So she said it was vacated. So he actually got his motion. She supported his motion. It's vacated, but she's gonna allow the summary judgment to be. It's like they reset the case to the back to the beginning.
And it is vacated.
No, no. Okay. The judgment I'm speaking of is him ordering it to mediation.
Okay, well, it doesn't matter. I mean, you don't have to go to mediation. It's fine.
Okay. Okay.
But what I'm saying to you is the next thing that has to happen before I set it for trial is we need to hear the summary judgment motion. And I've just showed you on the screen what the summary judgment motion is talking about.
Okay.
And why they're asking for it. So, I mean, I can't give you advice what to do. I'm just telling you that's going to be the next thing that's going to happen.
Summary judgment. Okay.
Okay, well, what is the date, Wendy? September 2nd at 10:15.
September 2nd, 10:15.
Yes, and Mr. Johnson, if you could notice that for me?
Yes, ma'am. And Your Honor, if we could get a confirmed address for Mr. Thompson?
Sure. Mr. Thompson, what would you like them to send you notice?
Of course, I cut that part out. This is where it's gonna get interesting.
Okay, is there anything else to come before the court on this matter?
No, ma'am.
Okay, Mr. Johnson?
Your Honor, the only thing is that Mr. Thompson's motion that he filed, the motion to vacate the judgment, when we received it, it was about a quarter of the page on the right side was not on the page. And when we tried to pull it from the docket itself, the docket only showed the first page of the motion. And
so he's trying to say that when he received that motion with the affidavits, he didn't get all of it.
That's some bullshit.
Right.
I'm sorry.
Well, let's listen.
Because when he was talking about some type of additional affidavit, I didn't see it.
I see it. Have you looked on the clerk's computer? I mean, I'm looking at it on the clerk's computer.
Well, when I look at it from the office, it only pulls up the first page.
Your Honor?
It doesn't show the full. Well, yeah, the copy that we received, it probably about only three quarters of the page on each page is actually shown. So you have like a quarter of the page to the right is all it looks like blocked out or white out, or when it was copied, it was somehow.
Okay, but on the clerk's computer, the copies are there.
Okay.
So I would just tell you to go, and there's an affidavit where he just talks about the items that he would like verifying receipts and things of that nature.
And Your Honor, you had
Yes.
you said send it to them 3 days prior to the hearing, so I sent it to them also. I sent them a fresh copy of it 3 days before the hearing. And
Okay.
yeah, so they got a copy of it also, additional copy, because I mailed it to them also. They got a mailing and they got a copy, email.
Got it.
Yeah.
Okay, thank you very much, everyone.
Thank you, Your Honor.
Okay, everyone stay well. Take care.
Okay, you too.
Thank you.
I'm back. Okay. Yeah. I'm glad I played the rest of that so y'all get to see hindsight in action. All right. So today we were gonna finish our conversation about these these repossessions that um that are unconstitutional. They violate your unalienable rights protected by the Constitution. Right? So I said I was going to read a case to you about it. What I want to do is find that TikTok and like let you watch it. Like it'll make your blood boil how he just goes in people's properties in their backyards. You know, he's not taking it from the front. He's just like going in to their backyard and just taking um those cars. And then the people ignorant, they don't know that they have rights.
I mean, what is the purpose of lying if we don't trust you? I mean, not much.
Oh, it just started playing. I don't know if y'all heard that. But it's gonna take me a little bit too much time to kind of find. Maybe on another show I'll show you this guy. And at the same time, I don't want to give him any more views. So I think it's disgusting. You know? You know, bullies like that, they don't fool with they come up against a guy like me or someone who knows their rights. They ain't gonna show that. Because I'm sure he got some cases where people like, yo, you better back up off me. He only showing the ones that give in, you know? So my camera, okay, there. All right, so let me share my screen. Let's see, make sure I'm sharing the right thing here. Share, Google Chrome. All right, this is self-help repossession versus the Fourth Amendment. So that's the Fourth Amendment that's the clause where it talks about the right of due process. You know, meaning basically due process means that you have to stand the test of a trial. Meaning they make a complaint, bring you in as a defendant, and they present their case and you present your defense, and then the judge decides who's right or wrong. That's the way the law is supposed to work. These self-help repossessions that they allow is to help these corporations make money. And it's unfair that they can do that they allow, and they're not being charged with theft, because that's what it is. It's stealing your property. Like I said yesterday, that car is titled to you. You are the legal owner of the car. Your name is on that title, or at least your straw man. When you go to DMV and present whose ownership, it's titled to you. So when someone is coming to take it, whether you owe someone money or not, a third party is stealing your car. I want you to get that through your head. Under the guise of a repossession, it's theft. Remember that. They're stealing your property. Why are they stealing? Because they don't have a court order to come pick up your car. They don't have the sheriff with them. Well, they do try to call the sheriff, and the sheriff gets in there and they help them because they ignorant and don't know the law like they should. Isn't it crazy how you got people enforcing the law and they don't really understand what the Constitution says about the Fourth Amendment? I think if someone is late on their payments, they should go to court and say this, that, and the other. Now, of course, they're going to say, well, we wrote it in a contract that you agree that we can allow a third party to come get it. This is the thing. That's why they don't like you putting all rights reserves on something. Like when we did the webinar yesterday, the guy was saying he went to DMV. They didn't want him putting all rights reserves, told him he can't do that. Why? Because they plan on taking your rights. And I'm telling you on things like that, write all rights reserved without prejudice. Write it. And when they give you pushback, you say to them politely, this is how I handle stuff like that. When they tell me I can't sign something a certain way, I say, okay, sure. I have no problem doing exactly what you say until you show me the rules where it say I can't do it. And I'll do it. Just show me the rules. And I'll do exactly what you say. I'll give you what you're asking for. And they'll tell, and when that happened to me, they just say, oh, have a nice day. They let me go. See, it wasn't a rule. They're just talking. People, this system is designed to make people react off of assumptions. Everything they do is often an assumption, not off facts. So people are getting locked up, going to jail off assumptions, not real facts. Think about it. So here's the case: self-help repossession versus the Fourth Amendment. Law enforcement officers are often called to conduct standbys for repossession agents, as they conduct self-help repossessions on behalf of creditors. Self-help repossessions is simply repossessions of a collateral based on terms of a contract rather than a court order. This is often allowed pursuant to state law as long as breach of the peace does not occur. So they're saying they can do it as long as, like, if you put up a fight, they gotta move on. Typically, law enforcement officers are called to the scene of self-help repossession in order to prevent violence or to keep the peace. However, law enforcement officers must be mindful that it is very easy for them to overstep the permissible or constitutional limits of their authority in these incidents. For example, consider the recent case of Hensley et al. Versus Gassman et al. Et al. Means and others from the Sixth Circuit Court of Appeals. The facts of Hensley taken directly from the case are as follows. On August 13, 2008, at approximately 3:15 a.m., Gassman, who repossessed collateral for lenders in the Ogdenmall County, Michigan area, went to the Hensley residence in Prescott, Michigan to repossess a four-door Buick. Plaintiff McClellan Hensley Sr. Hensley Sr. owned the Buick, but his wife, Sheila Hensley, drove it. After observing the Buick in the driveway at the Hensley residence, Gassman and his helper, Christian Wattrich, drove down the road and called the sheriff's department to request police presence, also known as a civil standby. During the repossession, Gassman requested police assistance because Hensley Sr.'s conduct during a previous repossession resulted in an assault charge against Hensley Sr., and Gassman was concerned about potential violence. Deputies Scott and Gilbert were dispatched to assist Gassman. See, they're assisting them to break the Constitution. The deputies met Gassman and followed him to the Hensley residence. When they arrived, the deputies pulled their patrol car onto the Hensley property, and Gassman backed his tow truck into the driveway toward the Buick, which was parked facing the house. At some point, apparently after they arrived, Gassman told the deputies that he had a repossession order and showed them a file containing some documents. The deputies did not read the documents. At the time, Hensley Sr. was away at work, but Sheila and their adult son, McClellan Hensley Jr., were at home sleeping. As the deputies walked towards the Buick, Sheila and Hensley Jr. woke up and went to the door. Sheila and Hensley Jr. stepped outside onto the porch and began telling Gassman and the deputies that they should not take the Buick. Hensley Jr. stood between the Buick and the tow truck to prevent Gassman from hooking up the Buick. Hensley Jr. shouted at Deputy Gilbert, who was standing nearby, as well as Gassman and Wattrich, telling them that they could not take the vehicle and had to leave the property. Deputy Gilbert responded that they were not going to leave and that Gassman was taking the Buick. Deputy Scott ordered Hensley Jr. to step out of the way. Hensley Jr. moved to the side of the Buick after Gassman bumped him with the tow truck while backing to the Buick. While Hensley Jr. was shouting at Deputy Gilbert, Sheila explained to Deputy Scott that her payments were up to date and the car was not supposed to be repossessed. At this point, when there's a dispute saying that payments were up to date At that point, the deputies should have stepped out of it. They have no right to keep helping because now it's a dispute. One person is saying one thing and the other person saying other. They don't know what the facts of the case. For them to allow that tow truck to take that car, they stepped outside of their responsibilities. And you'll see. Deputy Scott responded that he did not care, and if that were the case, she could take her paper with the Gassman and Burns Gassman client recovery in the morning to sort things out. In spite of Sheila's protest, Deputy Scott said that Gassman still had to take the Buick. In response, Sheila got into the Buick, started it, and locked the doors. She then lowered her window and shouted for Hensley Jr. to get her cell phone from the house. Hensley Jr. retrieved the phone and handed it to Sheila, and she put the window down. By this time, Gassman and Watrich were out of their truck and lying on the ground, attempting to hook chains to the Buick's rear axle. At some point, Deputy Scott went to the Buick's driver's side window and ordered Sheila to exit the vehicle. See, now they are helping them. Once the deputy steps in and he's helping them, that immunity is out the window. How are you going to take the side of a third party? You don't know any facts and help them take the car because they show you some papers. It's not a court order. Deputies are only required to follow court-ordered repossessions, not some paperwork coming out of somebody's office. They follow orders by the court, okay? Deputy Scott continued to shout at Sheila and threatened to break the window because Sheila had put the car in drive and was pulling the tow truck, which by then was chained to the car, towards Gassman and Watrich as they were on the ground next to the rear wheels of the Buick. When Sheila still refused to get out, Deputy Scott unsuccessfully tried to break the car window with the butt of his handgun. Now he's like actively participating in a repossession. That he's a third party too. After Gassman hooked up the Buick and Sheila's still out inside, Deputy Scott told Gassman to pull it out of the driveway, and they ordered this is the deputy telling the tow truck, go ahead, take it. But she did not comply. Deputy Scott then used a hammer to break the passenger side window, reached inside and unlocked the doors. Deputy Gilbert then opened the driver's side door and pulled Sheila from the car. Deputy Scott opened the passenger side car door, began moving items from the back to the front seat of the car, and told Sheila that if she wanted anything from the car, she should get it out now. After Sheila and Hensley Jr. retrieved Sheila's personal belongings, Gassman rehooked the Buick and towed it away. Lo and behold, later that morning, Gassman discovered that Sheila was indeed telling the truth about the payment. He had another tow truck driver turn the Buick to the Hensley. So she was telling the truth, and they're just helping them. You see? Crazy. The deputies did not arrest Sheila that morning, nor apparently did they even mention that she had committed a crime. Because she didn't. That's her property. About a week later, however, on August 21st, 2008, they submitted a warrant request to the prosecutor seeking felonious assault charges. On August 28, 2008, a judge signed a felony warrant charging Sheila with 2 counts of assault with a dangerous weapon in violation. So to cover their ass, they're going to charge her with a crime. See how crooked they get? Based on her pulling the tow truck toward Gassman and Watrich while they were on the ground. Following a preliminary examination, Sheila was bound over on 2 counts of felonious assault and a charge of reckless driving. On May 19th, this is her property. 2010, Sheila pleaded no contest in both counts of felonious assault and to a misdemeanor charge of attempt aggravated assault. Ultimately, Hensley filed suit against the deputies and a repossessing company under state law, which we will not discuss here, and Section 1983 for a violation of their Fourth Amendment rights regarding the seizure of the vehicle. The deputies filed a motion for summary judgment based on qualified immunity. So they're trying to get immunity from action because they felt like they was acting within the boundaries of their lawful duty. Well, we're going to find out. In order to determine if a law enforcement officer is entitled to qualified immunity, the court would typically first determine if a constitutional or federal right was violated. If the court finds the officer violated a constitutional right, Then the court will next examine whether that right was clearly established, such that another reasonable officer in the same situation would have known that he or she was violating the plaintiff's constitutional rights. Thus, the Sixth Court can first set out to determine if the officers violate the Hensley Fourth Amendment rights during the repossession of their vehicle. At the outset, the Sixth Circuit noted the Fourth Amendment protects the person's right to his personal property without interference from the police, absent consent or reasonable suspicion or probable cause that a crime has been committed, will be, or is being committed. Property is seized when there is some meaningful interference with an individual possessory interest in that property. A constitutional violation occurs when the seizure of the person's property is deemed unreasonable under the Fourth Amendment. In his case, the person that sought the seizure of the property was a private person rather than a law enforcement officer. These repo agents were attempting to engage in self-help repossessions, which is allowed by Michigan statute as long as the repossession can be accomplished without breach of the peace. That's important. That's why you got to raise hell. Thus, since the repo agents were the individuals seeking to seize the property, the deputies could only be held liable if there was a finding of state action or participation. The Sixth Court stated, government actors such as the deputies normally can be held responsible for a private decision only when they have exercised coercive power or have provided such significant encouragement, either overt or covert, that the choice must in law be deemed to be that of the state. Mere approval of or acquiescence in the initiatives of private party is not sufficient to justify holding the state responsible for those initiatives under the terms of the 14th Amendment. Thus the court had determined whether the deputies conduct in Hensley's case amounted to state or government action. The Sixth Court first stated, as a starting point, we note that a police officer's presence during a repossession solely to keep the peace, i.e. to prevent a violent confrontation between the debtor and the creditor, is alone insufficient to convert the repossession into state action. However, an officer can overstep the permissible bounds of the Constitution when he or she takes a more active role in a repossession or does an affirmative act that aids or facilitates the repossession. The court quoted the Ninth Circuit's holding in Howerton versus Guider and stated, an officer's presence at a repossession may constitute state action if accompanied by affirmative intervention, aid, intimidation, or other use of power which converts him from a neutral third party to the effect and assistant of repossessing party, 708 F2D. And just to give you my experience, I was helping someone, they worked for the post office, and they tried to repossess their car. And when they called me, what do? I said, go get in the car and then call the sheriff, right? So at that point, they couldn't take the car because she's in the car. So when the sheriff came, they didn't force that person out of the car. They just still by, they try to say, you owe the money and you need to pay it. I'm telling them it don't matter what is owed or not owed. Nobody knows that right now. It's under dispute. Your job is to make sure the peace is not breached. So they didn't help either person either way. They just stood there to make sure nothing happened. Then finally the tow truck let it down and that was it. You see? They're not supposed to actively come in and help the tow truck get that car like these officers did. Even without active participation, courts have found that an officer's contact can facilitate a repossession if it chills the plaintiff's right to object. As numerous state court cases and secondary authorities have recognized, an objection, particularly when it is accompanied by physical obstruction, is the debtor's most powerful and lawful tool in fending off an improper repossession because it constitutes a breach of the peace, requiring the creditor to abandon his efforts to repossess. So, this is saying that it's lawful for a debtor to, like, no, you can't take my stuff, accompanied by physical obstruction. So you can physically try to stop them. A police officer's arrival and close association with the creditor during the repossession may signal to the debtor that the weight of the state is behind the repossession and that the debtor should not interfere by objecting. Even if a jury were to find that Calvillian did not actively assist the repossession, it nevertheless could find that Calvillian's arrival with the repossessor gave the repossession a cachet of legality and had the effect of intimidating Booker into not exercising his right to resist, thus facilitating repossession. So just them calling him to help them is a act of assistance. Holding that a jury could conclude that the officer's presence with the landlord while the landlord disconnected the tenant's electricity could have endangered fear or intimidation, causing the tenant to refrain from exercising his right to resist the improper disconnection. You have the right to resist, okay? The Sixth Circuit then set out to apply the above discussed law to the facts of Hensley's case. The court noted that following relevant facts, the deputies responded to the scene of the repossession at the request of the repo agents. 2, a deputy ordered Hensley Jr. to move from behind the vehicle as he was protesting the attempt to prevent the repossession. The deputies ignored demands to leave the property. They were supposed to leave. A deputy told Hensley Jr. that the repo agents were going to take the vehicle. A deputy ignored Miss Hensley's protest and told her that the repo agents were going to take the vehicle. A deputy told repo agents to tow the vehicle out of the driveway as Miss Hensley was in the vehicle. A deputy broke out the window to the vehicle in which Miss Hensley was seated and unlocked the door. A deputy ordered Miss Hensley to exit the vehicle and remove her belongings. After examination of these facts, the Sixth Circuit stated, equally clear is that this conduct was not only active participation, but was instrumental to the repo agent's success in completing the repossession. Ms. Hensley asserted her right to object not only through words, but by physically taking control of the Buick. At that point, the repo agent's right to pursue his self-help remedy terminated. Y'all getting this jewel? That once you get in that car and they got to drop it. Because at that point, it's not peaceful. So you have all the rights on your side, but because these deputies, these law enforcement officers don't understand the rules properly, they behave the way these two officers behave, and you people lose. But it's good that they came back with this suit. Right? Hang on a second. Let's see what the chat. It's people asking questions about credit. I'll get to those questions later. All right, so let's go back. Terminated, and he was required to cease the repossession. At that point, they had to stop. Once that son came out there and said, hell no, and the wife went into the car and sat in it, they were done. They were cooked. They needed to go. But these two officers being big badasses, they want to assert their authority and help take people's property. As such, the court held that the deputies were engaged in state action. Next, the court had to determine whether this government action and the seizure amounted to an unreasonable seizure under the Fourth Amendment. On this issue, the court stated, the Supreme Court has said that the existence of a court order in a case such as this is a game changer. Assuming that the officers were acting pursuant to a court order, a showing of unreasonableness on these facts would be laborious task indeed. The court then examined the facts relevant to the issue of the reasonableness of the seizure. The court noted that the following relevant facts: the deputies knew this was a private civil matter and were unaware whether a court order authorizing repossession existed. The repo agent claimed they were authorized to repossess the vehicle. The Hensley disputed the repossession, gave a specific reason, and the deputies lacked any evidence which supported the repo agent's claim of authority, i.e., a court order. The court then held that these facts are sufficient to allow a jury to decide that the seizure was unreasonable under the Fourth Amendment. Since the court determined that the deputies participated in an unreasonable seizure of Hensley's vehicle in violation of the Fourth Amendment, the next issue relevant to qualified immunity for the deputies is whether the law was clearly established such that a reasonable officer should have known that his conduct was unlawful. To issue, the court stated, this court has long recognized that individuals have a clearly established right not to have property in which they enjoy a lawful possessory interest seized by state action in violation of the Constitution. Have a stick 32F3D at 994, footnote omitted. The Supreme Court's decision in Soldel, which was decided in 1992, confirms that state actors violate the Fourth Amendment by taking an active role in private evictions, repossessions, when there is no apparent legal basis for such action. Cochran 656 FVD at 309. Moreover, in Cochran, the court affirmed that the law was clearly established in this respect well before the events here at issue. Thus, the court held that the deputies should have known their conduct violated the Hensley Fourth Amendment rights, and as such, they are not entitled to qualified immunity from suit. Practice pointed. So, what can law enforcement officers learn from this case regarding standby involving self-help repossessions? Officers should remember the following. Officers should only be present to keep the peace or prevent violence. Y'all keep that in mind. Write that down. If you ever run into that, that's what you need to tell them. Hey, your job is to make sure the peace is not breached, not to help them take this vehicle. This is my vehicle. They're not taking it, period. Case law seems to suggest that if an officer that threatens to arrest a person for protesting a self-help repossession, he or she may be found to have facilitated repossession by preventing a person from exercising their right to protest. In states where state statute only allows self-help repossession, if it can be accomplished with no breach of peace, if a person protests a self-help repossession, the officers on the scene will be wise to advise the repo agent that due to a breach of peace, the repo agent will need a court order to proceed with the repossession. This is dependent upon state law regarding self-help repossession, but this is a good rule of thumb to avoid constitutional issues in light of United States Supreme Court holding in Soto versus Cook County. No, court holdings can vary. That's that. All right. There you have it. There's your power. Use it. Use it. They can't do that. Deputies can't come in there and help repo agents, although they do it all the time. And we allow it. Now you have this information. Y'all, I'm sure you know people facing repos. Share this video with them. They need to hear this. You have a right to physically stop someone from taking your property because it is your property. Unless there's a court order, it's yours until it is decided that you are in violation of the contract by court order. It's still yours. That title has not changed hands to no one. In order to change a title into the name of the creditor, they have to get a court order. But first, they have to go to court to do it. They don't want to do that. They want to pay the lawyers. They want to do. It's cheaper to pay some guy to come take it from you. That's cheaper. And then they go throw it into an auction or they make you pay all of these fees. All right, so let's go to the chat. Then I'm getting off. Go to the beginning. Peace. It says, Indy Circle says, peace, my brother. Peace back to you. Peace to the gods and much light. Lucan Apple states, Brecniel says yes. Karen says, happy Tuesday, everyone. Happy Tuesday back to you. And me, I'm saying like and share. Y'all need to share this for real. Because people need to know this. Because people be running scared. And man, Sea King Bay said, peace, everyone. Ins League says peace, prosperity, and extreme wealth to all. What's up, Akeem? What's up, back to you? And I also say peace, prosperity, and extreme wealth to all, as always. DJ Thunder said peace, love, prosperity, and extreme wealth to everyone. And Levita says peace to all. Son of the true one true king says peace to all. I don't see how nobody has sued him yet. It's crazy. What are you talking about? Sued who? In that case? Oh, you mean the guy that I was talking about on TikTok? Man, I don't see nobody has lit him up. That's what I'm like. After the injunction, he's wearing that he was wearing a bulletproof vest, so that means he's been somebody done pointed at him or even shot at him. After the injunction is sent to proper party and express trust is set up correctly, what's left? And is it just banking and booking from the trust? It sounds like you learning from somebody else. So your question doesn't align with my teaching. So I really can't answer what you're talking about there, Mr. Mike Rashad. That's not what you're talking about. Injunction sent to proper parties, express trust is set up. That's not my teachings, bro. So I can't answer that. I'm sorry. That's someone else's teaching. I know who you referring to. Who gave you that information. So my suggestion is go learn from them or get that question answered by them because that's their process, not mine. All right. I can't help you with that. Peace of God, do I find the credit repair information on your Sue Debt Collectors webinar or is that information in a different product? It's the Sue Debt Collectors webinar. It should be on my site. If it's not, send me an email. I'll send you a link to it. All right. Yeah, I don't get it. Like y'all come in here assuming that I teach stuff on Express Trust. You ain't never heard me say nothing about no Express Trust. The only thing I said about Express Trust is that's a term that people are using without really knowing what they're talking about. Every trust is an Express Trust. Every trust that got stipulations is Express Trust. So go back to my video called the Express Trust Scam. You'll learn about that. You know, I teach setting up trust, irrevocable trust, family trust, personal trust, grantor's trust, foreign trust, and then recouping your expenses throughout the year, bank accounts, mortgages. That's what I teach. I don't teach anything about injunctions and things like that with the trust and all of that. All right. Let's see. All right, there you have it. I read the case. Go use your power. Don't let them take your property. And with all of that being said, I think I did my job. Although I got on late, I apologize. But I gave y'all a whole, a little over an hour of information. So peace, prosperity, and extreme wealth to everyone. Y'all have a good night. But I'll say this, if you're sitting in a place and you having problems and you've been going to this place for all these years and your financial problems and your depression hasn't gone away, then you are in the wrong place, I would say. Because in order to make a significant change, become a new person, you pretty much got to get rid of 80% of the things you're doing right now to see some changes in your life. 80%. In some cases more. That's why I told y'all 10x is better than 2x. They articulate that very well. We assume that we can hold on to this and hold on to that and still become successful people. That's an assumption. But the fact is, it's not true. Because if those things that who you are today and what you've been doing up until this point today, still you not where you need to be, then there's some changes that need to be made. And that's the key.